Good day, everybody. I'm Richard Fink, a lawyer who specializes in workers' compensation law. Today's topic are the changes to the Workplace Safety and Insurance Act pursuant to the Protection of Workers Act the government introduced a month ago. And I'm going to turn it over to Paul to get us going on this topic.
Yeah, I seem to always get everybody going. Good afternoon or good day, everybody. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in workers' compensation law and human rights law. If you want to reach out to either one of us, Richard or myself, and be part of our podcast, you can contact us through the links below. As Richard said, this week's topic is Bill 105, I think it's called Working for Workers Act or something. And within it, what frustrates me, Richard, because I was watching the committee on Bill 105 yesterday, and like most Ontarians and Canadians in general, when the governments do these multi-thing bills, which I mean is they're amending multiple acts in one bill, it creates utter confusion because they were talking about actors getting better treatment and fairness. And honestly, I think it's very, in my opinion, very dirty in a way because they're doing this so they can say, look, see, the opposition won't vote for a bill so they don't like actor workers, whatever. And I'm like, come on. Why don't you be fair to people and make it easy to understand? So that was one big frustration. But specifically within Bill 105, as Richard said, we're talking about the changes or amendments to the Workplace Safety and Insurance Act, which specifically the main issues identified in it were the age 65 issue, where the government is claiming to increase benefits beyond age 65, which were taken away in 1990. I want to make that an important point because up until 1990, from 1950 to 1990, workers received benefits for, as Meredith said, who was a conservative, for almost 100 years for as long as the disability lasted. So that's the age 65 issue. Um, the one thing that many advocates for injured workers pointed out during the hearings yesterday, as well as in conversation, was that it's not an automatic right. So in 5 years, I'll turn 65. And what I'll have to do is I will have to convince, beg, plead the WSIB to continue paying me benefits beyond age 65. The what I'll have to say is but for my work injury and accidents, I would have worked beyond age 65. The problem is in most experiences with injured workers and what I observed in the hearings was the board is very, how we say in fancy terms, is very subjective, the wording. There's no, well, it has to be this, a test, a legal test, or no. It's just they can go no to Richard and yes to Pamela, and, for no reason or logic. The other issue is the 72-month lock-in. I do want to correct something that one injured worker advocate had said in the hearing. He had mentioned the 72-month lock-in has been around since 1990. That's not entirely correct. From 1990 to 1998, it was a 60-month lock-in, Richard, I think it was, and meaning that if you were receiving benefits regularly because you were partially impaired or completely impaired, partially meaning you could work, but the job you were doing didn't fully restore your pre-accident earnings, the board would give you what they call like a top-up of monthly benefits. Then after 60 months, or in the case of the Workplace Safety Insurance Act, after 72 months, they would say, okay, what are you making now? And then they would do what's called lock in your benefits. This meant, as all the injured workers and advocates had testified about, is it created stability. There was no more fear and worry about losing your benefits. And it was very interesting to hear from one injured worker, Merv, and I apologize if I butchered his name. I can't even say my own name correctly. He was talking about how he not only felt suicidal tendencies on the way he was treated by the board, he was actually in the hospital for attempting suicide. I myself have many times myself. Many injured workers deal with suicide, and one of these factors is the constant fear that the board, without reason or justification, can just say, well, I don't feel like giving you benefits today, Pam or Richard, so I'm going to stop. Now, the government, the courts will say they can't do that. That's not right. And like I always say to clients, and Richard and Pamela, you say this too. Well, the law says this, but like anybody, a person or an organization can do whatever they want. It takes time for the law, the appeal process to catch up. The problem with these workers taking the ultimate sacrifice of committing suicide or attempting or seeking MAID in some cases, there's an injured worker in Nova Scotia doing that, it's that lengthy appeal process. I mean, it can take 4, 5, 10 years. I have one injured worker right now. We went to the appeals, and the appeals officer said, yeah, you've got new medical. Well, yeah, And they said, no, this has got to go back to adjudication. Went back to adjudication. They gave them an NEL for this thing, but then said, well, we think you can work. So now we're back to appeals, back to the and that takes a heavy mental toll on the injured worker. It's ironic because Meredith, one of his points he said was, I want to get all this legal crap out of the way in the courts suing and make it easy for injured workers. If you've been injured, you have a right to workers' compensation. And in my opinion, we've lost that. So that's about the 72-month lock-in. And quite honestly, in my opinion, I think 72 months and 60 months is far too long. And I reference the AMA guide. If after a year, and in many cases, the board used to say, remember, Richard, the usual healing time chart for permanent injuries used to be 3 months for a soft tissue injury. I've talked to some injured workers 5 years and they haven't gotten an NEL award. So I think the lock-in should be once you've received a permanent, it's permanent. Nothing's changing, right? I think that's when it should be, not 5, 6, 7, 10 years or forever. So that's my quick view on that. The last one is the 90% benefits. In 1997, when Mike Harris was changing the Workplace Safety Insurance Act and when he was creating it and making it more aggressive against injured workers, one of the things they did was they reduced benefits from 90% to 85%. Now, I don't have a lot of experience in the pre-1990 law, which Richard does, and he has prior laws, which that's one good thing about dealing with Richard. If you're injured prior to then, he actually litigated cases many times in these. And I'm learning about them, right? And it is quite interesting that prior to 1990, workers received earning benefits based solely on their capacity to earn. Meaning, if I was a worker making $70,000 a year, it was based on that, nothing else. In 1990, they changed it to this NEL system, a flat rate system. Interestingly, in reading Meredith, that's exactly what employers wanted, and Meredith said no. So when you look at today, Richard and Pamela, it's interesting when you look compared to today, what employers and what the law has done compared to what Meredith said no to employers back in 1910 to 1915. It's interesting that employers have literally gotten everything they wanted. So those are the issues in Bill 105. What do you think, Richard or Pamela?
Well, I forgot to introduce Pamela Ford Hughes as part of our conference
It's
today.
okay.
Pam is a legal assistant in our office, and I wanted to throw out the following to Pam, which is now people can ask for benefits past age 65 if they were injured after the bill gets passed. And does the WSIB have the staff, the adjudicative staff, to start making these decisions? What's it look like there?
No, I don't think so. I haven't heard one thing about it. My other worry is they have a hard time making proper decisions now, so I don't see how it's going to change. If anything, it's going to get worse going forward. I have not heard one thing. I suspect what will happen is once this bill goes through, they're going to have another department, just like they have the CPD, psychotraumatic disability department dealing with those issues. They're going to have over age 65 or 2 years past the injury, they're going to have a set of case managers. I don't know what that's going to look like. I don't know if they're going to hire new staff. I don't know if they're going to bring other staff through. We don't know what this looks like. That's the problem with this bill, and that's what we've been talking about, is that we only have bits and pieces of information. We don't have anything concrete. Like we don't know what is the criteria going to be for whether or not you get the benefits past the current cutoff date. We don't know for the 90%, what does that look like? Do you have to make a certain amount of money? There's talk about all of these other things that might be put through. Another thing during a session this week with the removal of the lock-in that I didn't even think about. So right now we all know if you're not locked in, if minimum wage goes up and you're deemed to be able to make minimum wage, your partial LOE benefits are reduced because you always keep in mind it's 85% of the net difference between your pre-accident earnings and the earnings that they say that you can do. So once this removal of the lock-in is done through the bill, anytime minimum wage goes up, anybody that's not locked in anymore, their benefits will eventually start to deteriorate until they eventually could become nothing. There's also the aspect of the phantom job, which is I think that you can do this job making this wage, so I'm going to pay you partial. Now, somebody mentioned this during a session that I never even thought about this week, which is okay, if you live in a rural area and the WSIB is paying you partial LOE benefits because in that area, whatever phantom job they say you can do has a set earnings. But then let's say you move to somewhere else that is more populated and there's more job availabilities. The WSIB could potentially also say, oh, well, you've now moved, let's say, from, I don't know, the middle of nowhere to Toronto. There's more jobs and the wages pay more. Here's another reason why we can reduce your partial LOE benefits. Because now that you've moved, there's more chances that you can get a higher paying job. These are aspects that I didn't even think about, which is going to be very scary for all of these injured workers if and when this bill goes through.
Flip it the other way. What if you live in Toronto, Mississauga, the Golden Horseshoe, and you move to a rural area?
Yeah.
You know what actually happens right now? Well, since apparently 1998, to my recollection, I can't recall exactly, but I'll give you the history on injured workers moving. The WSIB, around 2000, I think it was actually suspending benefits and reducing benefits and deeming injured workers when they moved, declaring them uncooperative and things. Surprisingly, I'm being sarcastic when I say this, and I'm true when I say surprisingly, I mean, the Canadian Civil Liberties Union actually weighed in and told the WSIB, no, you can't do that. You can't punish a person if they move because they have a charter right, Section 6. And unfortunately, Doug Ford can't do anything about that because that's the one right that is what I would call a real right. And I won't get into rights too much, but Canadians don't realize that the governments can actually take your right to life away, but they can't take democratic and mobility rights away. The irony of it all. So they did that, and I was like, yes, right. But then as time progressed, like the WSIB does, they keep hammering it, and they actually now have a policy, and I kid you not, it literally says if you leave Ontario, now I don't know about moving, but I'm going to make that assumption in the policy, okay? So I could be wrong about that part. But if you leave Ontario, because that's the biggest thing in my mind, in my memory, and you do not get their permission to leave, whether permanently or temporary, or even for a job, because it doesn't give any exemptions, not only can they reduce, suspend your benefits, they can prosecute you in provincial offenses court. And I'm like, are you kidding me? I'm like, bring it on. Because it is a charter right violation. Moreover, the CCLA already said you can't do that. So it's interesting in the conduct of the WSIB how they treat injured workers, and it was fascinating to watch it. And to comment on what Richard said, Pamela, was Harry Goslin, who's been on our podcast twice now.
Yep.
Great person. He did do a presentation and he did answer questions. And the staff, and I know many injured workers go, oh, no. They don't understand. Many injured workers are so upset, frustrated, and I 100%, 110% get it. I do. But what a lot of them don't realize is the staff at the board are in a position where it's like, do this or you will get fired. Even though they have a union, it don't matter, right? They will make their life hell, just like they do with injured workers. And Harry came on this podcast several times to raise this to awareness, and he's right. And he literally said that working at the WSIB is, and don't quote me on this, I'm paraphrasing, something to the effect of, it's one of the worst jobs for stress level in North America. And he quoted some study. Um, he then went on and he talked about the age 65 issue. And he said, we do not have the staff for this. This will become impossible, basically. So he did actually mention that, and he did say the union is behind saying that benefits should go to age 70 or whatever. And there shouldn't be any review or anything. It should just be automatic. Another interesting point about the 90% was many, even politicians, and even I think it was MPP John Fraser, Lisa Schwab of the NDP, John Fraser was Liberal, and Jamie West were advocating that the 90% benefits should be retroactively applied to injured workers to January 1st, 1998. And they were saying, look, since 2017, employers have received over $21 billion in so-called safety rebates and employer premium reductions, right? So that was another point.
Can I just make a point about the age 70 for a moment? Alberta and British Columbia both will pay benefits past age 65 if the worker can demonstrate they would have kept working. And I haven't seen any discussion or any papers on how that exactly has worked in Alberta and British Columbia, i.e., what percentage of the workforce has been paid past age 65 with permanent disabilities. To what year did they get paid past age 65? What were the criteria used? What have the appeal system been doing with appeals in Alberta and British Columbia? Nothing has been discussed on that. No papers exist. And when I've been at meetings about the new legislation, it never comes up, which is really quite bizarre because we have really in Ontario for the new legislation, no idea what the framework's going to be.
Yeah.
It was mentioned, I remember, and I think it was Orlando from Injured Workers Consultants. He did mention that Alberta does allow it, and there's restrictions. But then he mentioned in BC that it's almost automatic. They send you a letter and say you're locked in. And an interesting point he said about BC is they lock you in and they say you can work if you want. This won't impact this at all. But he said 99% of injured workers can't work when they get this letter, which is true. I remember though, Richard, when I was studying back in 2014, so this was a while ago, I actually looked at all the provincial laws in Canada, all of them, including the territories. And Ontario was one of the few that did restrict benefits past age 65. Each province is uniquely different in its laws. They have little different tweaks. And it was interesting, like Manitoba has no time limit on appealing decisions. Saskatchewan is very different. I think, see, the problem with Manitoba and Ontario, Manitoba and Saskatchewan is that they were NDP always. So they were, how would we say, pro-worker, pro-injured worker, very fair. Then over the years, recently, they became conservative. So then the laws and the conduct of the boards became very aggressive towards injured workers. But now, interestingly, in Manitoba, it's recently become NDP. And they've just recently are doing a review of the compensation system. So it will be very interesting to see the report on this review that Manitoba does. And that's interesting too, because their law, Manitoba, says they must in law do a review of the system, in an independent review. I think it's every 5 years or something. Another point in comparison of laws and things is like what Marv was talking about is the appeal process and the delays, right, Pamela? And the injured workers begging and pleading, when am I going to get something? Alberta, and this has always been pretty much always NDP, or conservative, sorry. And then remember the NDP cleaned house and became the government. At that time, the Alberta government, when it was NDP, changed the Workers' Compensation Act. And one thing they put in, which was really interesting, is only in Alberta, nowhere else in Canada. They allow for what's called as interim benefits. So if you're applying for workers' comp and it's been denied, if you appeal, you can apply and request to get interim benefits. And I love the argument because they said, why should you go on social assistance in Ontario, Ontario Works or Ontario Disability Support that is paid by taxpayers? Remember, workers' comp is paid through premiums by employers, businesses. Why should I have to pay for you, Pamela, if you get injured and you're waiting for an appeal for 2 years? The employer should have to pay through collective liability, right? And what was surprising in my observations is when the Conservatives then won the election, took over from the NDP, they kept it in, the interim benefits. Now it applies to employers as well. I don't know how, but I haven't really studied that side.
Well, let me ask a question about the employers. Have they been doing submissions at these open hearings?
They have, but I missed because in the morning, yesterday morning, I was in the middle of a motion hearing, so I missed the morning segment, which there was employers, I believe, and lobbyists for employers there. I first caught the Minister of Red Tape. I can't remember her name. And I caught quite a bit of, I caught her presentation and then Lise Francois grilling her about how she has no understanding of the system and how it's impacting injured workers is very good. But to answer your question, I don't believe there was any employer reps in the afternoon. It was mainly just workers, like injured worker organizations. There was IAVCO, IWC, Steve Mantis from Oniwig, Workplace Health and Safety, the lawyer for them. He actually got an applause from the gallery, which the chair went, no, no, no. And I kind of laughed at it. I thought, oh, so we're not allowed freedom of expression at the legislature. My sarcasm. So it was very insightful.
The question is, are the employers in favor of the changes because they think it will reduce costs?
I don't know. I'd have to ask Lise to find out because she was there, obviously, or Jamie West and
I
see.
mean, just looking at the minimum wage is going up way more than inflation.
Yeah,
So
and it's
as you
ironic.
say, presumably at the 10-year mark following the injury, all those workers who've been deemed to do minimum wage, their benefits are going to be reduced by 20-30%.
That was a comment that Lise and quite a few others, Lise Fauchois, made about the lock-in and the benefits, and that was that the workers' compensation benefits to injured workers is not keeping up. And quite honestly, I think there is a genuine stigma with business and generally with society and with government, especially the conservative government, that workers' compensation is welfare and it's taxpayer funded when it is not. It is just like, say, car insurance or liability insurance for a business when somebody slips and falls. You know, I wrote submissions yesterday and I filed them with the committee. And my submission, my argument was basically, and it's pleading to the government and to employers that you keep pushing and taking from injured workers. And eventually, what will happen is the courts will eventually agree and say this system doesn't work anymore. We're going to have to declare it unconstitutional. Now, many would say, oh, they would never do that. And I say, yes, they will, because they almost did in 1987 in Medwin v. Ontario. They said the law was unconstitutional based on Section 15 of the Charter, violates right of equality. But at the time, in 1987, the court said, because of the historic trade-off, then workers had a right to workers' compensation, and in return, they lost the right to sue their employers. Fine. But in 1990, the law changed. That historic compromise has been literally compromised. Workers no longer get a right if you've been temporarily injured. You don't get workers' comp. You don't get anything for your pain, your suffering, your lack of mobility. And if this legal argument is presented to a fair and impartial judge, decision maker, I think they would sit there and go, yes. And it's not something that I want to advocate for. It's something that I want employers and government to realize. Do you realize what you're doing? This is not welfare. These people have a right, a lawful right of redress. They've been injured and they have this right. And if you legislate that right away, the courts will eventually be forced to go, yeah, we can't do that. We can't allow this anymore.
Let me add another question to this lack of lock-in, which I haven't heard from any of the reps, which is if you get an LOE determination following a return to work plan in year number 3 of your injury, they'll often say you can do something like customer service at minimum wage because you're just starting. And then when they get to year 4, they're saying, well, you've been doing the job now for a year, even though the worker hasn't. So you can now make the median wage. So the first wage is like $17 an hour. The median wage will be like $19 or $20 an hour. And then presumably when you get to year 7 or 8, because now there's no more lock-in, you can now make the higher end of the wage, which will be $22 an hour. So take the worker who is making $22 an hour at the time of the injury, and when he gets the initial decision, he's still getting $100 or $150 a week from the WSIB. By year number 7 or 8, without the lock-in, he's going to get nothing. So this is a formula. We don't know the exact way it's going to work, but it's a formula to cut workers off entirely from workers' comp.
100%. 100% that's what they're doing. And
Yeah,
there's going to
so-
be all of these different things that are going to fit into it. Like, oh, if the person moves, are they overemployed? Are they underemployed? We found this. We don't even know how often the WSIB is going to be reviewing the situation once the lock-in is removed. That's the other thing that we don't know about. The government either is going to put in a duration of time or they're going to leave it up to the WSIB, which is terrifying to even think about not having an actual like annual review. It's just there's going to be way more problems than we have now. There's going to be tons more of appeals. Everybody has said that, the Appeals Services Division and WSIAT are going to get completely backed up. And I mean, it's not going to get any better. It's going to get significantly worse because, as we all know, decisions don't get rendered properly to begin with now, and then we're going to see that going forward with the removal of the lock-in.
And one thing about the decision that wasn't mentioned surprisingly yesterday was that in the advocate circles, I believe it was Kendall, and I want to give him credit, and IWC, I believe, had studied decisions at the tribunal. What they studied was the initial decision, meaning you appeal to the board, like Richard's done thousands of times, and myself, I've done some, and in relation to the board. And it's a measure, in my opinion, and many, of the quality of decisions. And I believe, and don't quote me on this, it was around 70%. Now,
Yeah.
so in other words, 70% of the time the board is wrong, right? Now, what I realized, I started looking at reconsideration decisions. I was fascinated because I'm like, that geeky type. I wanted to know who's winning, meaning how is the representation, meaning are they lawyers, are they paralegals, union reps, OWA, are they self-represented? And I hadn't completed 2025, but from January to March, I found, I believe it was 12, there were something like 17 or 20 reconsiderations made, or something like that, and 7 were granted. 3 were self-reps that they completely lost. The OWA lost. 1 lawyer won, and the rest were paralegals. So that was interesting. I think it's just because paralegals are more predominant in the workers' compensation realm. But what was interesting to note was there was more overturned decisions within the WSIAT, right? So in other words, where you're looking at the 70% is my point, that number actually increases to say 80% or 75. Then again, another point is with a reconsideration, it's not just one and you're done, although the tribunal in many cases will say, yeah, that's it. I love their statement. We have limited resources, so sorry, you're going to have to starve. That's my opinion and my feeling. And when I read these words, it's really insulting to those injured workers suffering. And I think the tribunal should either reword it or get rid of it altogether. It seems they're prioritizing their finances over justice, in my opinion. But at any rate, an injured worker can do a reconsideration as many times as necessary if the case is warranted, meaning if there was an error of law, whatever. And you can do that many times, and some I've seen as high as 4 and 5, right? And maybe on the third or fourth one, the decision was finally realized as wrong, right? Then also in the next step is judicial reviews. So my point is, as you go through the appeal process in looking at maybe a window of decisions of the board, well, initially that the research study said it was 70% approximately, and they're right, but it would be further complemented by looking at reconsiderations at the tribunal, as well as ombudsman too. They can, well, not do it, but they can instruct the tribunal to do it, and then finally judicial reviews as well. Now, the point I'd like to make about judicial reviews is, as of 2019, with the Vaviloff decision, the door is open more for fair judicial reviews, and I have seen a lot more against the tribunal or board ruling in favor of the injured worker, which is good, and employer.
Let me just conclude with one statement, which is my psychological advice for my clients, and I'm a long way from being a psychologist, is to let's finish with the WSIB. Let's get as close to a fair result as possible, and then you need to move on. You need to be able to say, here's the types of things that give me comfort. Here's the types of ways I can avoid thinking about my disability. Here's reviving my social life, and get on with your life and try and do the best to try and enjoy it, because you're going to be dead sooner or later anyways. And I've got a case that I went through a couple of days ago with my client who lost his facial skin to a large explosion, and he's in year number 9. And fighting with the WSIB now, going on 10 years, is not healthy. It's retroactive and it's retrograde. And in his case, it's going to attack him until he's dead. And it's a real travesty and very unhelpful. So on that basis, we'll conclude for the day, and thank you all, the listeners and participants. Bye-bye.
Thank you guys. Take care.